Donald Trump and his defense team now demand access to a classified filing that Jack Smith's attorneys sent to the judge and never copied Trump on. It's called an ex-parte filing. And Trump's defense says, I want to know what was in there. In normal filings, when the government submits something, they notify the defense, but they didn't do it this time, and Trump wants to know more. Before we take a look at the actual filing, I want to introduce you to one of Trump's new lawyers. His name is Emil Bove. You can see he comes from New York. Blanche Law Firm, he entered in his notice of appearance, and that's what it looks like right here. They sent this in to the clerk of the court. They said, hey, Angela, clerk, what's up, Angela? Says, I am now appearing as a new retained lawyer, Emil Bove, and we learned that this guy's kind of a powerhouse, right? Former SDNY, former prosecutor, somebody who's done a lot of criminal cases, now joining the defense. So that's always good news for the defendant to build out their legal team. Now, Trump's team has also filed a notice of compliance with their security procedure protocols, saying, Your Honor, here's our notice of compliance. Pursuant to an earlier court date, Trump's lawyers, John Lauro and Gregory Singer, now submit that we have submitted all of our security clearance documentation. There's this organization called the Litigation Security Group that works with the U.S. Department of Justice, and they're going to be vetting and verifying that these guys have security clearance to take a look at certain documents. They say counsel, Trump's lawyers, are in communication with LSG regarding their applications for their security clearances. They say we further anticipate that we're going to request clearance for an investigator employed by the defense to also assist. So we got classified documents in this case, and this is the January 6th case with Judge Chutkan. And so Trump is saying we're jumping through your hoops so we can even review the evidence. And now they've submitted another motion. And I want to break down what's going on here because this is a motion for access to a CIPA filing, right? Trump has not seen this document yet. The government submitted this directly to the judge and bypassed Trump's defense. And Trump says, I want to see it. Now, typically in a certificate of service, they'll copy both sides, right? We see this oftentimes in simple motions, like a motion for a continuance. Both sides know about it. But this involves what they say is sensitive materials that Trump doesn't need to see. Trump says, here's a motion, Your Honor, that has come in, and we want to know more. We're at a critical juncture. The government is asking the court, Judge Chutkan, to endorse the withholding of discovery. Prosecutors are asking the judge to hold discovery away from Trump. And it doesn't matter whether the material is relevant or helpful to Trump. Government wants Trump to not have it regardless. Trump's defense says, Your Honor, in effect, because CIPA creates no new rights, prosecutors filing this motion are seeking permission to withhold Brady material. Okay? Brady material, we all know what that is because that's exculpatory material. The Supreme Court has told us that if the government is in possession of information that might exonerate the defense, they've got an affirmative obligation to give that to the defense because the defense doesn't have that material. They don't have access to the body cams and the blood results and the crime labs and the evidence lockers and all of the things that the cops wrote in their reports. So if the government knows that there's something innocent in their big gobbling up of evidence, they got to give it to the defense. But the government in Jack Smith's case is saying that that Brady material might be CIPA material, classified information that is precluded from the ordinary course of discovery. Okay, I know this is very in the weeds and very, multiple layers deep, but it means Trump's not getting the evidence that the government has in their possession due to CIPA classified material garbage. Outrageous. The motions require the court to stand in the defendant's shoes, Chutkan, and predict defenses that Trump has not yet presented and that he's entitled to develop as the case proceeds to a jury. We've got to protect the defense and give them exculpatory materials when necessary. Now, in contrast, CIPA makes clear that the court may, but need not allow the prosecutors to shield their submissions from Trump. So Trump can't even see what this is going to the judge. Trump says, now, while we acknowledge the court has discretion to allow this, in this crucial setting, like we know you have the right to do this, we respectfully submit that doing so is not necessary. We seek attorney's eyes only access to the paragraphs and the submissions that are not portion marked as classified and to the office's citations to legal authority, which are not classified. It's outrage. Like Trump can't even see the evidence. Okay, he was the president. He was literally the president, but they can't show him the evidence. So Trump's lawyers have to resort to begging to just take a look at the footnote documents. Can we just see what you cited to? Now, in light of the court's order regarding public access, we recognize that any redacted version of this would be maintained under seal and subject to protective orders. We're not going to disclose it. We just want to see it, man. They say the court should exercise its discretion here. This case involves materials that are explained in the following way. They say, here, the court has discretion under the law. They say the general presumption is against ex parte proceedings, right? We want both sides to know what's going on. We don't want either side to just go to the judge behind the other side's back. That's the standard, normally. The development of other laws have given the intelligence agencies greater permission to summarize sensitive information. So if a defendant wants info, you don't get it all, but you can get a summary of it. A case involving a clear defense counsel who've already been approved should get access to these things, right? They've already been approved in other circumstances. And they say they're giving us a bunch of law that we'll fast forward through. They say here, now, while we presume that Jack Smith's office has marked its motion with a banner headline talking about its classification status, the office is not an original classification authority. So Jack Smith might have deemed some things as classified, but he doesn't get to do that because he doesn't have permission under the rules. Any classification of the office's submission is a derivative classification, and prosecutorial claims about sensitivity did not change that. That is why citations to legal authorities are not deemed classified, right? So they just want bits and pieces of what's happening here. They say also this is non-classified, and so it's also going to be protected. There's not going to be any subsequent disclosure. In order to obtain relief, they must invoke special privileges, and only upon an invocation of those special privileges should they withhold evidence from Trump. So we respectfully submit that Jack Smith's office should not be permitted to withhold this evidence without granting President Trump access to the non-sensitive portions of its submission. Respectfully signed and submitted by Todd Blanche. Short filing, but very interesting thing happening there, okay? It's very technical filing. They're trying to just get this, basically, okay? So the prosecutors filed something, and we don't know what's in it. We can't see anything in it, but they're making an argument that some of that is discoverable because it's not classified. So in the government's filing, they probably had entries that look like this, okay? Footnotes or citations to other cases. And so they're saying this portion is not classified. So we should be able to see that. And if they can see that, they'll say, oh, the case is about Stevens. Oh, it's about communications between prosecutors and trial judges. And so they'll be able to reverse engineer what is happening and try to fill in the blanks. But it is par for the course, my friends. Jack Smith and his government sending ex parte motions behind Trump's back, trying to keep the documents in there away from the defense. And Trump's people think it might actually have Brady material that is discoverable, but they'll use technicalities to say it's classified, it's protected, Trump doesn't need to see it. We'll see if they get access to the footnotes or to anything else inside as the prosecution continues with Trump's new lawyers and new security privileges. We'll continue to cover, my friends. Thank you for liking this video. Thank you for subscribing. Thank you for leaving a comment, and we'll look forward to seeing you on the next one.